Welcome to We Dissent, the podcast with secular women attorneys discussing religious liberty issues in our federal and state courts and our work to keep religion and government separate. I'm Rebecca Markert with the Freedom from Religion Foundation.
And I'm Alison Gill with American Atheists.
And I'm Liz Cavell, also with the Freedom from Religion Foundation.
In today's episode, we are going to discuss the Religious Freedom Restoration Act, otherwise known as RFRA. And to help demystify RFRA, we are excited to welcome an icon, another secular woman attorney, Professor Marci Hamilton, to the show. For those of you who are unfamiliar with her, I'm going to give you a brief bio. She's had quite an incredible career, and I'm going to be skipping a lot of it. Professor Hamilton is a professor of practice in the Department of Political Science and the Fox Family Pavilion Non-Resident Senior Fellow in the Program for Research on Religion at the University of Pennsylvania. She is a leading and influential critic of extreme religious liberty and the author of God versus the Gavel, The Perils of Extreme Religious Liberty, which was nominated for a Pulitzer Prize. Marci successfully challenged the constitutionality of RFRA at the Supreme Court in City of Burney versus Flores in 1997 and defeated the RFRA claim brought by the Archdiocese of Milwaukee against hundreds of child sex abuse survivors in Committee of Unsecured Creditors versus Listecki in the Seventh Circuit in 2015. Hamilton clerked for the United States Supreme Court Justice Sandra Day O'Connor and Judge Edward Becker of the United States Court of Appeals for the Third Circuit. Also of interest to our listeners, she is the founder and CEO of Child USA, a nonprofit think tank that pairs cutting-edge legal analysis with original social science research to improve laws and policies related to child abuse and neglect. Professor Hamilton is the leading expert on clergy sex abuse and sex abuse statutes of limitation. She is the author of Justice Denied: What America Must Do to Protect Its Children, which advocates for the elimination of child sex abuse statutes of limitations. We will put a link to her think tank, Child USA, in the show notes. Welcome, Professor Hamilton. My first question for you, Marci, is you were one of the first clerks for Sandra Day O'Connor. Is that correct?
In the earlier years, yes. She joined in 83 and I clerked in 90.
So you clerked for the very first woman justice of the U.S. Supreme Court. One of the reasons we started this podcast was to also raise the voices of women secular attorneys and just women who work in constitutional law. So I think that we would all be really interested in hearing about what that was like.
So Justice O'Connor became kind of my, mother-in-the-law person in my life. And she was this extraordinary, and I shouldn't say past tense, she's still alive, but she's not well. But she was this extraordinary mix of just down-home common sense with brilliance. And I've never met anybody who knew how to work professionally and talk to anybody in the world more professionally. So it was a gift. There was never a sense that I was clerking for the first female justice. I was clerking for the original Sandra Day O'Connor. And she never wanted it put in those terms. Although what was truly amazing about her is that because she was the first female justice, she received invitations from all over the world to address every possible event. And she took a lot of them. I mean, she really was an ambassador for the court, even more so than the men on the court for a number of years. And it was all about public service. So really was lucky to clerk for her.
Wow. Our topic today is the Religious Freedom Restoration Act. And we have talked about it previously on this show, given our listeners a brief synopsis of what the law is, but we'd love to hear it from you. Can you briefly tell us what RFRA is and why it is unconstitutional?
So RFRA is the Religious Freedom Restoration Act. It was passed in 1993 the first time in response to Employment Division versus Smith, which was a case about whether or not drug counselors could be fired and then not be paid unemployment compensation because they use an illegal drug. It so happened they were using an illegal drug during a religious service. So they argued that they had a right to use that drug regardless of the law. The case went to the Supreme Court, and a majority of the Supreme Court said, no, you don't. Just because you're religious, you don't get to get around all the laws that apply to everybody else. This was directly in the face of the conservative evangelical Catholic movement that started in the 1980s to essentially set up a world where religious believers have more rights than everybody else. So they were very upset when the court came down with this decision, which, by the way, was exactly what the court had always been saying. There was no news in this decision, but they made it a cause célèbre, and they persuaded Congress, who had no clue what they were doing, that the Religious Freedom Restoration Act was a great thing. The core of RFRA says the following: if you are religious, you can avoid the law unless the government can prove that it passed the law for a compelling interest, and this is the part that's most troubling. And the government needs to be able to prove that this law is the least restrictive means for your religious beliefs. So the way RFRA operates is through the imagination. So let's say you have a law that says that you're not allowed to build a house of worship in this part of the city because it is residential. The RFRA response to that is that, well, nothing under zoning law is compelling. And secondly, what is the least restrictive means in order to accommodate these religious believers in this circumstance? And courts have answered that by saying, well, the least restrictive means would mean that the town will buy the building you already bought and will make sure that you can locate in a building that you would really like. Or it means that, oh, yes, you are in a residential district, but you're going to get the zoning that nobody else can get because you're religious. So it's created this unfortunate world where religious believers are being told by the law that their claims are preeminent above all other claims and that the law rarely should apply to them.
RFRA has had a substantial impact on litigation regarding church-state issues, in many ways, I think, allowing the development of doctrine to help get around Smith and advance the free exercise jurisprudence. Can you talk about RFRA as a tool for litigation by Christian nationalists? I think it's an important thing people should understand.
Well, RFRA is the sword of any religious group, especially Christian nationalists, who want to get around the laws that apply to everybody else. And the unfortunate and one of the most dangerous aspects of RFRA is that even the courts get confused. And so, because RFRA is just a statute, it could be overruled tomorrow, and that would be perfectly constitutional. It's just a statute that gives every religious believer more rights than the First Amendment does. And so by creating this religious liberty right, the courts and the public get confused and they think RFRA is the Constitution or RFRA is required by the Constitution. They talk like that all the time. There was a decision that just came down recently, and then the court only ruled on RFRA and kept talking about the claimant's constitutional rights. So there has been an effort to make RFRA sound like and operate like it's just part of the First Amendment, which, by the way, was the goal. But that's not accurate. It's just a statute. And the First Amendment never intended historically and should never mean that because you're religious, you have a right to get around the laws that apply to everybody else.
I really appreciated your work opposing religious exemptions to school vaccination requirements. I feel like there's been a lot of state legislative development in that area, for example, in Maine, where they're repealing religious exemptions. And also, there's been some recent litigation in Mississippi in this area that basically say there must be religious exemptions based on, I think, a state version of RFRA. So I guess I'm curious. What are your thoughts on the state of the law regarding vaccination exemptions and RFRA, and how do you think this will shake out?
Well, just as we saw with the COVID vaccines and the military objections to having to take the COVID vaccine, RFRA is creating this leverage to be able to argue that laws that are intended to benefit the common good, the greater good, like vaccine laws, should have exemptions for the religious believers, which is ridiculous because the more exemptions for vaccines you get, the more you lose herd immunity and the more danger you introduce to pregnant women, children, and the elderly. So it is so sad to see Mississippi even edging close to an exemption for vaccines. Mississippi, if you can believe this, Mississippi was the best state in the country for vaccine compliance.
Really?
Yep.
Absolutely. And the reason for that is they had no exemptions. And what they proved, I mean, they were a scientific petri dish. If you don't have exemptions, you have a lot less illness and you have fewer deaths. And that's and nobody questioned it in Mississippi. It was just, yeah, everybody gets their vaccines and we just go forward and the kids get them to go to school. Maine is not terribly different, though they didn't have exactly the same health record. But the push back to reinstate the religious exemptions that we have been working so hard to remove over the last 20 years is a direct demand to let people die of treatable illness. When the governor of Kentucky let his children go to what he called a chickenpox party, I was appalled because not only is chickenpox very uncomfortable and sometimes deadly to children, but it's the basis for shingles, which is one of the most painful diseases known to man. So that's good parenting. No, it's not good parenting. And, one of the things we're working on at Child USA, the main thing is the civil rights of children. Children should have a civil right to be vaccinated so they're not sick now and they're not sick in the future.
I really appreciate you bringing up the civil rights of children. There's been this wave of parental rights bills across the country, and a lot of them have language that's almost exactly taken from RFRA, saying that basically any infringement of parental rights, it gets strict scrutiny protection. So instead of any sort of infringement on the rights of free exercise, any infringement on quote unquote parental rights. And I sort of see this as like the next iteration of RFRA. And I'm curious if you have any thoughts on this, if it's an issue that you're watching, especially being such an expert in this area.
Absolutely. So what's going on with parental rights is, so the world signed on to the International Convention for the Rights of the Child. And it included rights to health care and vaccines and education and not being abused and not being separated by your parents. Everyone but us. The last two holdouts were Somalia and the United States. The United States did not sign on to the rights of the child that every other country agreed with, including the Vatican, because of the parental rights movement at the time. So this is decades ago. The concept of parental rights is intended to hand back to parents the rights they've lost to harm their children. We did not have a law against child abuse until the middle of the 19th century. In fact, the first organization to prevent abuse was for animals. The ASPCA was founded before the first organization for the prevention of cruelty to children. And so we have had painstaking but honestly good advances for the rights of children, the right to speak, the right to be fed, the right to be educated, the right not to die from a medical illness that your parents would let you die from. So what we got right now is a backlash from the conservative parents' rights movement. But what the American people need to fully understand is that what parental rights means is that the law does not protect the child from harm. And that's just intolerable.
I don't know if we quite got this far on just the quick elevator pitch of like, what is RFRA? But our organizations have argued, and so have you, that RFRA is unconstitutional. And so I just want to kind of explain what our argument is, why RFRA is unconstitutional.
So, of course, I took RFRA to the Supreme Court in the Bernie v. Flores case. And we argued, and the court agreed, that RFRA was unconstitutional in a variety of ways. One was that it was unconstitutional for the federal government to force the states to dance to a different tune with respect to religious liberty. But the more important ones were that it was a violation of the separation of powers. I mean, think about this. The Supreme Court reaches a conclusion, a holding, that there is no right to get around the law when it is neutral and generally applicable. So that's the law that we have from the First Amendment. And then Congress enacts a law that says, hey, Supreme Court, you know nothing about the First Amendment. Here's what we say the standard is. This was a literal hijacking of the First Amendment by Congress. And the court said as much in the Bernie opinion. The third reason that it was unconstitutional, according to the court, was that this was a takeover of the constitutional amendment process. If you don't like the result of the court's interpretation, your only route normally is to get a constitutional amendment. In this case, they simply walked across the street from the court to Congress, got a simple majority vote in Congress to change what was supposed to be the religious liberty standard in the United States. So it's unconstitutional in three different ways. But the lobbyists for religions, as soon as Bernie was decided, went to the airwaves, went to Congress and said, oh, it was really only unconstitutional as applied to the states. And so we can now have a federal RFRA. And at the same time, the Rutherford Institute, a conservative Christian organization, started to spearhead moving RFRAs across the country in numerous states. So we ended up with a federal RFRA, and now half of the states have their own RFRA.
Right. We know the Supreme Court can analyze statutes, and it can also analyze constitutional language. What RFRA is doing is changing the standard, the test, or the analytical framework by which the court should analyze constitutional text. That's not a normal statutory function of Congress. And so it's actually wild how widespread this movement has been only in the religious liberty context to control the way that courts analyze our constitutional rights by legislation.
Well, so I don't completely agree with that interpretation. So what they intended to do was to get the First Amendment to be interpreted by Congress, and that Congress then was setting the standard for the First Amendment, which is what you just described. But actually, in effect, with respect to all the ways it's been interpreted, they passed just a statute because they didn't have the power to change the First Amendment. So what we ended up with is a First Amendment side by side with a statute. The worst thing that's happened is that the First Amendment is now sidelined in the vast majority of religious liberty cases where RFRA is available. And RFRA's become the governing standard. And it's become the way in which certain religious entities, evangelicals, conservative Christians, and Catholics are saying that's how you interpret religious liberty. So they are intentionally saying a statute's the Constitution. It's not. It's a statute. It could be repealed any day and it wouldn't have any effect. But by displacing the First Amendment and putting in this statute, in effect, religious liberty against the government is now being dictated by a simple majority in Congress. And that's where the harm lies.
But since RFRA has been put in place, there have been numerous developments, especially recently on the court, that undermine like Employment Division v. Smith and move us closer, I think, to a RFRA framework, even if the court hasn't affirmatively taken that step. Isn't that right? How do you see that? How do you see things progressing in that direction?
Well, the court hasn't yet interpreted the free exercise clause dramatically differently. I mean, all we've had is Fulton. And in Fulton, what we found out is that Amy Coney Barrett looks at things a little bit like Justice O'Connor and says it's context dependent, standard is going to be. But of course, in Fulton, which was the Catholic foster and adoption organization that didn't want to have to adopt gays, in that case, the holding was that the city was being discriminatory because it wasn't applying its standards evenly.
Yeah.
So they haven't done that. What they've really done with the Establishment Clause, though, which is a different side of the coin, is to completely decimate it. They have removed all of the interpretive mechanisms, except a very few, for the Establishment Clause, which has opened the door to say that there is no limit on religion. So under the Free Exercise Clause of the Constitution, under the First Amendment, you have to obey neutral and generally applicable laws, but under RFRA, you don't. And then under the Establishment Clause, there are no meaningful limits on your access to government funds, on your access to government messaging, and on your ability to force public school systems and other neutral systems that have dollars, forcing those dollars to the religious groups. So RFRA is bad for the country in terms of what people have been brought to believe, that religious believers are on a higher level than everybody else. But secondly, the Establishment Clause doctrine has opened the door for religion to now fund itself through government funds. Essentially James Madison's turning over in his grave.
I think that's a really great point about the Establishment Clause. I was referring not only to Fulton, but also to the Masterpiece Cake Shop case and to the Tandon case. And so it's been I think in a few different ways that they've been sort of attacking the basis of Smith from different angles. You know what I mean?
Well, no, but Masterpiece, they went off on a technicality on the public accommodations laws. The one true disaster is the Elena's case, the case involving the wedding website that insisted on discriminating against gays. In that case, though, it wasn't decided on free exercise or Smith, it was decided on speech. And it was a super valued speech that all of a sudden no interest is strong enough to overcome, including discrimination law. So there's really three tacks the court is taking to empower religion and disempower the culture. And one is the Establishment Clause being decimated. One is letting RFRA be interpreted so broadly that it permits discrimination. And then free speech being used as an absolute right to get around the laws that should apply to everybody else, and particularly the public accommodations laws.
We've seen so many questions presented to the court trying to overrule Employment Division versus Smith. Do you think that's still a top target for them, even given their recent wins over the last 2 years at the court?
Well, the Christian nationalist movement, which, is really the amalgam of very conservative Catholics led by Leonard Leo at the Federalist Society and evangelicals. It's not just about getting rid of Smith anymore. It's getting as many rights as they possibly can against everyone else in the culture. They lost, hands down, the culture wars. And they are now trying to win a space for themselves where the culture war conclusions, there's gay marriage. You have to treat gay couples like any other couple. You have to treat gay families as families and not as second-class citizens. The rights to abortion were increasing until Dobbs. So they want a universe to turn back the clock, and they want to live where none of those rules apply. And they are riding RFRA as hard as they can to get there. One of the ugliest successes they're having is the ability to discriminate against gays in just ordinary for-profit corporations. And it's all based on RFRA undermining Title VII. So what's their agenda? Their agenda is to never mix with gays. Their agenda is to never let women have abortions. And their agenda is to make sure that children are their property without independent rights. And when you take those three together and you see what they've done with respect to the RFRA claims, the attempts to enlarge the pre-exercise claims, which have not borne fruit quite yet, and the Establishment Clause, it's time to wake up. It's literally time to wake up. And, I've been sounding this call to action since 1997 when I won the Bernie case. And it's just even more true today. We are facing a movement to theocratize the United States in their vision. And everyone, including the vast majority of religious believers in the United States, the secularists, and everyone else needs to stand up and say, I don't want to live in a theocracy.
I really appreciate that call to action. I think you really have a clear tone about where things are going and an important warning. I wanted to ask about discrimination. You mentioned, of course, that RFRA is being used to undermine discrimination laws. And I guess there was some recent cases in the Fifth Circuit, or maybe one case in the Fifth Circuit, the Braidwood Management v. EEOC, and I think it's now known as U.S. Pastor v. EEOC, where there was a decision. I wonder if you could talk a bit about that case, because I think it's a really important one to understand what's happening.
So, we have several cases, one in particular that's made the most progress, in which essentially what's happening here is that we had an interpretation of Title VII. Did Title VII cover gays? And the answer from the Supreme Court, shocking to the world, but they weren't paying attention. The answer by the Supreme Court through Gorsuch was yes, Title VII covers gays. But in the middle of that decision, he said, but don't forget, everybody, RFRA creates opportunities to discriminate that nobody else gets. And so what's happened is the movement to move gays away from the far-right citizens is that they are now in court and they are arguing that their religious liberty requires them to not have someone who is gay in their employ. So far, they've won. And the ugliness of this is that it is the expansion of this concept that not only do you have the right to exercise your own religion, to believe that you and your family shouldn't be gay, not only is there that right, but see, they've expanded it to their proselytizing model, which is they are insisting on the right to force others not to be gay. And that's the Rubicon. That's where you enter theocracy, and that's what they're seeking.
And we're talking about suits against third parties too, potentially. So this isn't even about the government, which is normally what RFRA is used to sort of protect against government action, right? We're talking about if a company is discriminating, a religious company, and a person who is employed there doesn't want to face this religious discrimination and sues, their argument is that they should be immune from federal non-discrimination law in this area. Is that right?
Well, it is. I mean, what's going on here is that every federal law is mediated by RFRA. There's not a single federal law, the way RFRA is written, that does not have this blanket rule that there has to be this draconian accommodation of religious believers. And so, when I testified against a reenactment of RFRA after the Bernie case, one of the things in my testimony was, if you enact RFRA again, and as applied to federal law, you are going to water down civil rights. You're going to water down Title VII. And everybody at the time was like, oh, you're overinterpreting. That could never happen. It's such a compelling interest. It's the least restrictive means. And lo and behold, it's being used to undermine Title VII. And of course, the ministerial exception case of Xana Tabor is being used to say that ministers, not just clergy, but ministers in religious organizations can be fired for discriminatory reasons, and the religious organization is not responsible. So everybody needs to understand what they're trying to do is carve out a universe where gays don't exist for them, where they don't have to deal with them, they don't have to have business with them, they don't have to have them in their employ, and they don't have to treat them with respect. As I said, this is their way of winning back the culture wars that they so badly lost.
Our organizations, both Freedom from Religion Foundation and American Atheists, we were opposed to RFRA also from the beginning, and we have called for its repeal. You, Marci, have written a brief arguing just that for the Freedom from Religion Foundation. But given that we are now in the wake of this ultra-conservative Supreme Court majority, and the federal bench has changed so drastically, the legal landscape has changed so drastically. As you mentioned before, the Establishment Clause has been decimated. We do believe that they are working to elevate free exercise rights only of Christians and not anybody else. But what our organizations are facing with, and a constant conversation piece that we have in many meetings and litigators meetings, is just, is it now the time to embrace RFRA as non-believers and then try to use it to advance a secular democracy or secular government? What are your thoughts on that?
Well, truth be told is that as bad as I think RFRA is, both public policy-wise and also constitutionally, I represent 7 members of the clergy in Florida who are invoking RFRA against the Florida abortion bans. I was called and asked if I would be involved in such a case. I said only if we can have a spectrum of believers to show the country that a majority of believers believe in reproductive rights as part of their faith, including that secularists have positions on abortion that have nothing to do with the Dodd's conservative Catholic ruling. And so right now, RFRA is a weapon that can be used to show that every religion, every believer has a right to be treated with its special treatment. And I think ultimately, once the country wakes up and it realizes that it is in fact a diverse religious country where the vast majority actually believe in reproductive rights, I think once we get to that point, I think RFRA starts looking a lot less attractive to these groups. I'll never forget Georgia Representative Bill Barr voted for RFRA, and then there was a story that it was being used by Wiccans on Army base in Texas. And he publicly stated that RFRA was never intended to help them. And I think that's exactly what's going on here, right? What's going on here is they patched together a group of religious groups that had no clue what they were doing, including the ACLU, People for the American Way, Americans United, Yay, Yay, Yay for Religious Liberty, RFRA. They had no understanding that they were now going to undermine one of the great things about American society, which is that we have lived for centuries without a religious civil war. You can't find that in many countries. And RFRA undermines that by making certain believers higher up, but it was all being driven underneath by the evangelicals and conservative Catholics, as I said earlier, who had been joined together in the 1980s in order to put into politics their religious beliefs. So we're at a crossroads now. The country either stands up and says religious liberty for everybody, but not extreme religious liberty for anybody, or we really are facing the beginning of a theocracy. And the irony here is, why did people settle early in the United States? Because they were escaping deadly theocracies. And here we have a group that is intent on reinstating the kind of tyranny that our founders would have found terrifying and disgusting.
You've spoken to this, Marci, about your litigation in Florida representing faith leaders and the spectrum of believers and non-believers on abortion rights. Rebecca mentioned, like, we always have this kind of push and pull as people who kind of loathe RFRA and think it's unconstitutional, but of course see it being wielded against us. And we spoke with Liz Reiner Platt, who works at Columbia on the Law, Rights, and Religion Project. And she's a big advocate for using religious exemptions, including state and federal RFRAs, as a tool for progressive ends. And so I know you're doing it, and I'm just wondering if we can speak a little more broadly about what you think about it as a strategic approach. Do you think it's a winning strategy? Have you seen wins on progressive use of state RFRAs?
Interestingly, state RFRAs aren't invoked a whole lot, which I find fascinating.
Interesting.
And they often don't win. What is dividing us right now, in my view, is a country where a minority of religious believers have become persuaded that they have the way forward for everybody else. And that way forward is that everybody else has to obey their dogma. So what happens when RFRA is used for everybody? It disempowers the single use of the RFRA by the radicals. Having said that, I will always believe, of course, I've got books that say it, and I'm writing another book now saying it again. RFRA is divisive to society because instead of focusing on what is the best law that's the best for as many people as possible, it leads you to ask the question of, how can I get away with breaking this law? And that is how you lose unity. It's how you lose community. It's how you lose public health. Before the RFRA reasoning infected the American public, essentially the wide majority of Americans believed vaccines were absolutely necessary. And the only exception to that were Hollywood types who were persuaded by a doctor in London who had made up his data and had to stop being a doctor. So that's what was going on with the vaccine movement. You start throwing RFRA at the vaccine requirements, and then you end up with, in the military, individuals who spend tremendous amounts of time together. Some of them don't have to be vaccinated. Some of them can make everybody else sick. That is the opposite of what the military is trying to accomplish in the greater common good. And the same is true with respect to any law. Here's my vision for how it should work. I said this first in God versus the Gavel, the first edition. I said it most recently in 2014 in the second edition. What should be happening is that if you want, first of all, RFRA should be repealed. And if you want a religious exemption, you want an exemption to a law for any reason, you should have to go to the legislature and make your case. And if your exemption from that law doesn't harm anybody else, fine. Then the exemption's legitimate. But if your exemption is going to harm people, say kill people, or destroy children's lives, those exemptions are illegitimate. And I would include right now the faith-healing medical exemptions in states like South Dakota, where you have graveyards where there are more infants buried than adults. When you've got a situation where there's going to be death and illness and the destruction of people's lives, there should be no religious exemption. I don't care what your religion is. And that's the future. It should be a matter of public debate and discussion. Most of these religious exemptions in existence right now were not subjected to public discussion. And the RFRA discussion was covered in misinformation and disinformation. And to this day, people think they have what is good religious liberty when what they have is destructive.
So we only have a few more minutes left. I feel like I'm probably the human interest story co-host of this podcast. I'm just so...
Somebody should be.
I'm always really interested in hearing people's backstories. And, You are one of the very few women who have actually argued before the U.S. Supreme Court. And I would love to hear just some of your thoughts or an anecdote from that experience.
It's ironic that when I did the oral argument in the Bernie case, the Washington Post, I got a lot of good reviews on the argument, partly because the justices were in sync with what I was saying. But there was an article the next day that very few women repeat at the Supreme Court, having been there once and been successful. And I'm one of those people. I have never been back at the Supreme Court. Now, I've written amicus briefs that have been cited. I've written amicus briefs that the reasoning has been borrowed. But it's a man's world to too much of a degree. And that hasn't changed a whole lot even now, 30 years later.
This has been a fabulous discussion, and I think that our listeners are going to learn a lot. I know I learned a couple of new things after listening to today's conversation. Do you have anything else that you want to add before we go?
The only thing I close with is this. It will take the American people reclaiming true religious liberty, which is kind to others, for us to get out of the emerging theocracy we're facing. People are going to have to stand up and say, I'm a believer, and I don't believe that you should be able to exclude gays. I'm a secularist, and I stand up for gays in the workplace. And literally, we need a repeal of RFRA. Until that happens, we're still at risk of what could end up being, terrifyingly, a religious civil war.
Thanks, Marci. You said you're writing another book. Do you have a sense of when we can read it? When it will come out?
So it will come out in 2024. The title is, you're going to laugh. The title is I Told You So.
I actually love that.
Yeah, I appreciate that.
And so I'm putting together my favorite of all the writings I've done in 10 chapters with a lead into each chapter to say, guys, come on. This has been a threat since 1997. Let's do something about this.
I love that. It's
love
your
it
Nostradamus text. Look at all my prophecies come true.
I feel like
it's my last stand. That's maybe I'm standing at the Alamo, but I am determined. I'm not leaving silent. So,
well, I look forward to reading that one.
Me too.
Thanks for having me today and putting up with my insane schedule.
No problem. Thank you so much.
Before we wrap for today, I'm calling all listeners. If you have a burning question that you would like answered by me or Rebecca, we're going to be doing a holiday mailbag episode that'll be released in January. So again, you can go to our website, we-dissent.org, or you can hit us up on the socials and submit any questions you have about the secular world, the Establishment Clause, the Free Exercise Clause, all your burning constitutional law questions. Send them to us, and if we can, we'll answer them in our January episode.
So that is it for today's episode. If you don't already, please be sure to check us out on our socials that Liz mentioned. We are on Twitter, which is now X, Facebook, and on Instagram. You can also find us online at we-dissent.org. We'd also love to hear how you are enjoying our show, so please remember to leave us a review. Thanks so much for tuning in. I'm Rebecca Markert.
I'm Alison Gill.
And I'm Liz Cavell. Thanks for listening.
We Dissent is a joint production of the Freedom from Religion Foundation and American Atheists. It is hosted by attorneys Liz Cavell, Alison Gill, and me, Rebecca Markert. Production support comes from Greta Martins and FFRF's summer law clerk, Emily Romero. Audio engineering provided by Audio for the Arts based in Madison, Wisconsin. Thanks for listening.